issues not only affect us, but they affect the entire community. And I also invited the other criminal defense bars for that very reason. So I am hopeful that she will accept our offer to hold another forum where both candidates can be present and we can both hear their views on the issues that are most important to us. I'm very glad that Mr. Schwartzbach decided to still participate regardless of the fact that it's just going to be him. And based on that, our format has completely changed. And so we're just going to, we have 10 questions that we're going to ask, approximately 10 or 12. I'll leave that up to the moderator. And give him as much time as he wants to respond, and then hopefully leave time for questions from the audience at the end of this. And speaking of our moderator, I'd like to welcome retired Judge Samuel Stevens here today. We're really honored, Judge Stevens, that you agreed to participate, and we're very happy to have you here today.
Thank you.
And without further ado, let's get this going.
Okay, Zach has been relayed to me through somebody's email, an introduction of himself, and I'm supposed to read this as opposed to you. It's probably better that I read this now that I've gone through it. Very cleverly done. Zach is a lifelong resident of Santa Cruz County, running for judge at the Superior Court. Hold up, I wish the font on this person's email. He is currently a deputy public defender. Zach has always been drawn to public service. As a Superior Court judge, he looks forward to having the privilege to serve the community he loves and grew up in. After graduating from local public high school, Zach worked and attended Cabrillo College. There he began his relationship with his wife. Eventually, the two transferred to Cal Poly in San Luis Obispo. Prior to having children, the two traveled as often as they were able. Now most of their free time is devoted to raising their children and participating in their sports and activities. I missed your wife's name in there, Megan. Zach has thousands of hours of experience working in the courtrooms of Santa Cruz County and extensive jury trial experience. Zach feels his experience has prepared him to immediately step into the role of a trial court judge. He believes his proficiency in the courtroom will allow him to calmly and fairly handle the responsibilities of the position. Zach entered the race for judge because as a practitioner in our local courts, he understands the importance of staffing the bench with judges equipped with extensive local courtroom experience. He is also nice to his mom. So, as Lisa said, the format here is going to be a little bit different. We don't want to be silly, but at the same time, we do want to have a format. Most importantly, everybody remember is there are good and bad things about the ethical restrictions placed on a judicial candidate. The good thing is we have judicial elections and they're open and people have an opportunity to be heard. The bad side is it is very difficult to draft a question of any substance to submit to a judicial candidate that they can answer with any substance without violating ethical rules. I noticed in passing just the article in the Sentinel 4 weeks ago, the endorsement article, is the candidates apparently been asked by the Sentinel editorial board what they thought about what was going on with the recall election over in Santa Clara County. How remarkably naive that was. But so what we're going to do is we've got 10 questions prepared by your board, and I'm just going to go down to them. It's supposed to be 2-minute answers. We're not too concerned about the specifics. If it starts to drift, I'll let you know. He's going to go through those, okay? Then rather than going to the backup 10 questions, that's going to get a little old, quite frankly. You may ask him questions as either just whatever you want to ask him about or follow up to his answers. Again, if you ask a question that I feel is over the line, I will say so. I've also told Zach, even though these questions have been vetted, he feels any of these questions, the answer to these questions would compromise him ethically, he will speak up as well. So I hope that's relatively straightforward. This is A little bit awkward, but we're gonna go ahead and do it anyway. Okay, are you ready?
I'm ready.
Okay. What do you believe are the root causes of high numbers of minorities incarceration? What changes can the court system make to reduce these numbers?
So I'll start with the root causes. I think that it's undeniable that there is a relationship between poverty and criminality, and we know there's ample statistics telling us that minority communities are disproportionately represented also in impoverished communities. And so it's not just about somebody's hungry and they need to steal a loaf of bread, but there are these external pressures that exist, environmental pressures that exist for people living in these communities. One that I've seen in particular, working the last 2.5 years in the juvenile delinquency system, or juvenile justice as some people are calling it these days, is that we have a housing crisis in Santa Cruz County. And it might seem a little attenuated to draw a line between the housing crisis and criminality, but for juveniles in particular, I think the housing crisis puts a lot of pressure on families. Both parents often have to work one or maybe even two jobs each. You have extended periods of time as a consequence of that, where young people are unattended, so there isn't a parent there or some responsible adult ensuring that they're going to school, ensuring that they are engaging in what we call in the trade pro-social activities, but sports or things other than hanging out, smoking pot, getting involved with theft-related offenses like that. And it's almost undeniable, I think, to link that back to our local housing crisis and that top-down kind of pressure that it puts on families in creating not just a need to commit crime, but also opportunities, periods of time of being unsupervised in these types of situations. So I would say that's the linking. What was the second part of the question?
The second part of the question is what changes can the court system make to reduce these numbers?
It's
25 words or less.
It's very often that the judicial candidates get these questions. What changes can the courts make? We can't change the law. We are bound by the law that we follow. But what I can say is I think that we can be advocates for collaborative courts that are proven to be effective. I personally think that the loss of the drug court and Prop 36 review court in Santa Cruz County was a tremendous detriment to this community, and now in the post-realignment era where the old law enforcement tools are not available to address low-level drug use, drug possession, and theft-related crimes. We need to look back at those other tools that we have while we wait for funding to start addressing those issues as public health problems rather than law enforcement.
All right, thank you. Do the principles driving the quote "Me Too" unquote and quote "Believe all women" unquote movements have any place in the courtroom? Why or why not?
I have yet to hear it called the "Believe All Women" movement.
That's the first time I've read it.
Right, but I understand that is a sentiment there. First, I just want to say that I think that this is an incredible era that we're living in. Women are seizing power in an unprecedented way, and really, if you study power dynamics in societies at all, true power has to be seized, and that's what is happening now. As a father of a daughter and 2 sons, I'm excited to be raising them in this era. How does that factor into the courtroom? Judges have a responsibility to make sure that courtrooms are a safe place, that everybody who participates in the process, whether it's the attorneys, the court staff, the defendants, or witnesses and victims, are able to come there and feel safe. And as a judge, you have to maintain that environment. And I think we know that there are some judges locally who excel at maintaining a very professional environment, an environment where people feel they can come and be heard, whether they are a victim or alleged victim of some kind of sexual assault, or they're a person being accused of that kind of conduct.
What are your thoughts on bail reform and the utility and fairness of bail in general? What can judicial officers do to make the bail system fairer?
Well, there are anecdotal instances where I've personally seen through representing criminal defendants that bail predatory might be a little bit too strong of a word, but the bail system often disenfranchises already struggling poor people in our community. You might have a young man or young woman who's incarcerated, and the family pulls together whatever meager resources they have to get a bond posted so that that person can get out. Because in that instance, it obviously appears to be of paramount importance that your loved one gets set free from the jail. If that's a way you can do it, then I don't know what parent or loving family member wouldn't want to do that. What can the judiciary do about it? We can take advantage of our systems that we have of supervised OR release. We have electronic monitoring, there's GPS, there's alcohol sensors, there's just checking in by phone, there's checking in person. There are all sorts of mechanisms in place, and there is data backing all of these pretrial release systems, saying these are successful programs, and in fact, we could probably be expanding them, because I think the success rate or return rate, or however you want to turn that phrase, on people released on pretrial release is something like 96%, something in that area, which means we could probably expand it a little bit, and even be releasing more people without putting the burden of imposing bail on them.
If you observe the defendant in your courtroom being poorly represented by an unprepared or ineffective defense attorney, how would you handle it? If you observe that a particular prosecutor was ineffective or difficult in his or her dealings with others and management of his or her caseload, how would you handle that? Will you hold prosecutors and defense lawyers to the same standards? Why or why not?
It's a really interesting question, because as a judge, you're going to be experiencing this tension where you're seeing exactly what's happening in the courtroom in front of you. And being somebody who's worked in the courts for the last 10 years, I've seen highly effective attorneys on both sides of the aisle and highly ineffective attorneys on both sides of the aisle. The role is not to take actions that are going to advantage or disadvantage one side or the other. And so to be in the courtroom coaching one attorney or another in a way that potentially is going to give them some sort of advantage would be, I think, unethical. However, due process is important, and fair and competent representation is important. And so you would just have to evaluate it on a case-by-case basis. And if I see that somebody, if I'm witnessing firsthand ineffectiveness, and there's varying levels. There's some people who just are uncomfortable in the courtroom and uncomfortable in the adversarial and open public setting there. That's one thing. But to see somebody who's not calling or not actually working up their cases, showing up unprepared, like clearly unprepared, having not read reports, having not just done the basic bare minimum of what is required, then I think at some point it is incumbent upon the court to step in and ensure that the defendant is being adequately represented. Same goes for the district attorney. If you see somebody who's struggling to prosecute a case effectively, it's not appropriate to coach them on how to do it. I have tried many, many cases, and I've had judges interfere, or from my perspective, interfere in the process in the courtroom, and it is maddening as being one of the practitioners. It's inappropriate. On the other hand, if there's somebody who's not competently doing their work and fulfilling their obligation to ensure that the obligation of the executive branch of the government, which is to ensure that the laws are faithfully executed, it might be appropriate to contact a supervisor or reach out in some way so that people who are in a position to take some appropriate action are at least aware of what's happening. And then there was a third part of the question, I don't know if I answered it.
Different standard for your decorum as a judge as it relates to prosecutors or defense attorneys. I assume that would include constitutional issues.
Right. So I hope that, I think I've created a reputation for myself in this courthouse in that I fight hard for my clients, I get good results for my clients, but I also treat people respectfully. And I have been able to maintain good relationships with not just my coworkers in the defense bar, but also I think I have pretty good, or at least civil relationships with most of the people working in the district attorney's office. I'm not going to hold anybody to a different standard in terms of how I treat them, but I do recognize there are different roles in the courtroom, and I think that's something that is often lost. The prosecutor has a role, and there is some tension in their role, because on the one hand, when they go to trial, they're trying to prove their case, they're trying to win, but they are the representative of the state, of the people, and they have certain obligations to disclose evidence, to be forthright, to make sure that someone's rights aren't being violated. On the other hand, you have the defense, there are different discovery obligations, and their role is to do everything legally and ethically possible to defend and advance the interests of their clients. So I wouldn't treat people differently based on their role, but I would certainly always be aware of the different obligations of the practitioners appearing before me.
What are your views on the high rate of mentally ill and substance addicted persons accused of crimes? As a judicial officer, how will these conditions factor into the discretionary decisions you have to make regarding individual offenders?
Well, we know that the Department of Corrections is the largest mental health provider in the state of California. There's an undeniable connection between criminality and drug addiction, and criminality and mental health. I think that the tools for judges to use in considering those are already built into the system. We have listed factors in aggravation and mitigation to be considered in sentencing. We have listed factors to be considered for supporting or denying grants of probation. I've many times read a probation report making a recommendation and seeing, either typically it's the factors in mitigation, the response is none. And I was up all night the night that before my sentencing memorandum was due, applying those factors and recognizing that they are broad, and you can look at all the factors of a case and incorporate them into those existing factors to be considered in the process. And certainly mental illness is something that, and drug addiction and the relationship between the two are things that have to be considered in that process. Does it mean that someone who has a mental illness should never be sent to prison? That's not the case. There are certainly situations that might call for that. But we have to be aware of that. And we're in this kind of bold new era where our understanding of neurology, of mental illness, it's expanding constantly. And so as a judge, I think you need to stay up on that. You need to stay up on the science and stay up on top of these issues. I think also we need to take advantage of and expand, to the extent that our resources allow us to, the use of our mental health court, or behavioral health court rather. There's a trend of clients who really need that service, but are deemed too challenging to work with, being denied access to that program. And that's just, those are exactly the people who need that level of supervision. The people who are voluntarily showing up and taking the medication and participating, I think they can be downgraded to a lesser level of supervision very often. And so we need to make sure that we use those tools to their highest level of effectiveness. And another factor to consider, I think, is that the personality and the demeanor and the ability of a judge to engage with the people appearing in front of them can have a real impact on their buy-in to the process. Judge Manley in Santa Clara County, he runs this really amazing mental health court, and it's a model that people refer to. If you ever meet Judge Manley, he's got an eye patch, he's very outspoken, he's very animated, and I have no doubt that it is in large part due to his personality and his commitment and his ability to communicate to people and get them to buy into the process that makes what he's doing in that courtroom incredibly effective, not just the existence of the courtroom and that particular rehabilitative approach.
This question is in the form of a hypothetical. Assume your presiding judge has directed you to make a concerted effort to clear a backlog of serious criminal cases awaiting lengthy trials. On the eve of trial in an aged, serious case with a lengthy time estimate,